Welcome to today's courtroom drama, where legal strategies unfold and tensions rise. We're kicking things off with Omar Smith's case in issue of delayed discovery and mounting evidence. How will this impact his trial date? Will the prosecution or defense hold the upper hand? Stick around, because this one's only getting started.
Court does call the case. People of the state of Michigan versus Omar Smith. Morning.
And good morning, Your Honor. Joseph Hall, appearing for and on behalf of Mr. Smith, as well as
Good morning, Your Honor. Michael Vitz, on behalf of.
Why do I get both of you?
Jan amend.
I'm sorry.
just a lucky day, Judge.
Yeah.
Just a lucky day.
To start out. All right.
Your Honor,
Is Mr. Smith here?
Yes, sir.
Mr. Smith, could you state your name for the record, please?
Omar Smith.
Thank you, sir. All right, what are we doing?
Your Honor, we've spoken with counsel. As you know, the nature of this case, there's an extensive amount of discovery that's outstanding. We have communications on that. I know he's doing his best to facilitate the same. We would ask for an additional adjournment of the PCC date to accommodate that discovery process.
Okay, so there's more discovery to come that hasn't been obtained and
Exactly.
Yeah.
We just got the autopsy report, Your Honor. The slugs that were pulled out of the car still at the MSP lab in Northville. When they're done there, they have to go to Detroit for ballistics. So there's the investigations.
Okay. How much more time are we looking at?
I would say at least 4 weeks.
I agree.
Mr. Vincent, did you want to? You don't care. All right.
I'm just happy to be.
Never mind. Is 13th. Why don't I adjourn it out to December 18th? See.
That date works with our calendar, Your Honor. Thank you so much.
Thank you.
December 18th, 2025, 9 a.m. Bond continued. Well, thank you, Mr. Smith.
Welcome. Thank you, sir.
Court calls case People versus Lloyd Sanders. Good morning.
Good morning, Your Honor. Gemma Dadish on behalf of Mr. Sanders. Mr. Sanders, can you please state your name for the record?
Lloyd Sanders.
Thank you.
Your Honor, there is an offer on the record. Wayne County's entire Zoom was filled up this week. I'm going to have to adjourn to be able to discuss that with him and get the plea form ready before his next court date.
The 4th, or you want the 11th?
The 4th should be good, Your Honor.
Probable cause conference will be adjourned December 4th, 2025, 9 a.m. Bond continued.
I'll talk to you tomorrow, Mr. Sanders.
Court calls case People versus Edward Byrne.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
Oh, there you are. Okay, good morning.
Good morning.
Byrne?
Yes, Stephanie Cannon on behalf of Mr. Byrne, and he should be appearing by Zoom, Your Honor.
Byrne, can you state your name?
Moving on to Lloyd Sanders. The pressure builds as he requests more time. But with a full Zoom court calendar, are we seeing legitimate delays or just more legal maneuvering? A courtroom's efficiency is crucial, but at what cost to justice? Let's see if Sanders gets the extra time or if the court holds him accountable.
In this particular matter, he just recently received actual paperwork from the friend of the court stating he may have be overpaying. And I want to take a look at that before we potentially waive it up to circuit.
He overpaid or is overpaying?
They're going to relook at it because his W-2 makes substantially less, and he has been making substantially less since the order was entered. So they're trying to figure out what went wrong. At least that's what it looks like based on the paperwork I received. I want to just be able to review it and see what's actually happening in the friend of the court case.
All right. Madam Attorney General, you know anything about that or?
Not, Your Honor, but I have no objection.
All right. Want the 4th or the 11th?
Your Honor, the 11th would work better. But like I said, once that's done,
Would.
we'll likely just be waiving the very next day.
Probable cause conference will be adjourned December 11th, 2025, 9 a.m. Bond continued.
Thank you.
Thank you.
Thank you, sir.
Call case People versus Terrence Ginyard.
Good morning, Your Honor. Assistant Attorney General Clarissa Williams on behalf of the people.
And Assistant Public Defender Jay Bellinger on behalf of Mr. Ginyard, who appears via Zoom, Your Honor. Mr. Ginyard, can you please state your name for the record?
Terrence Ginyard.
All right, you need to turn on a camera, please.
I'm trying to, Your Honor. 1 second, sir.
Apologies, Your Honor.
All right, there he is. All right, he's waving.
He is waiving, Your Honor. There was an offer made in this case, and we just need to get his bond applied to the arrears at this point. But the offer is, if you don't mind that I read that on the record, if he begins paying his ongoing support and pays the arrears down to $7,400, approximately 25% of the arrears, which he's already done, and pleads guilty as charged, the AG will ask the court to place the defendant on a delayed sentence under 771. If he continues to pay his order during delay and pays the arrearage down by 50% to $5,000, the charge will be reduced to attempted felony non-support. And if he pays the arrearage in full, the charge will be reduced to disorderly person or non-support. With that understanding, Your Honor, we will be waiving the preliminary examination.
And that's a correct statement of the agreement.
Yes, Your Honor.
Yes,
All
sir.
right. Mr. Ginyard, you're waiving your right to a preliminary examination. You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes, Your Honor, I understand.
And you understand that you'll not have that hearing and that you'll proceed to circuit court for further resolution on this matter.
Yes, sir, I do.
All right, people also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant found over to circuit court on both counts.
Your Honor, we acknowledge receipt of information, waive formal reading, stand mute at this time.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pre-trial will be set for
January 6th at 1:30 with Judge Kunke.
January 6, 2026, 1:30 before Judge Kunke.
Thank you, Your Honor.
Thank you.
Bond will continue.
Thank you, sir.
Have a good day.
You do the same. Court calls the case People versus LaRon Moore.
Good morning, Your Honor. Michael Vincent on behalf of the law.
Edward Burns' case takes an unexpected turn, an overpayment dispute that could change the trajectory of his financial obligations. As attorneys review paperwork and uncover inconsistencies, the courtroom comes to a standstill. What happens when numbers could decide fate? The case isn't just about the law, it's about fairness.
Still review. At the appropriate time, I'd like to make a bond motion too.
Adjourn this matter to December 11th, 2025, 9 a.m. without objection. As to bond.
Right now, his bond is 25,000 cash or surety. I'm requesting a somewhat lower bond, maybe a $15,000 cash or surety, 10%, if that is within reason.
Response from the people.
The people would object. Bond is set relatively low considering the nature of the offense. This is an armed robbery and a home invasion charge. The defendant does not have significant criminal history, showing just a misdemeanor, possession of a master key, a motor vehicle, and that a juvenile driving with a license suspended was dismissed. However, based on the nature of the offense and the danger to the community, people would object to any modification of bond.
Anything else, Mr. Vincent?
He would be tethered to his mom's house for all appropriate conditions.
I would agree that, quite frankly, that bond is set low, given the fact that the defendant is facing a capital or life offense, potential life offense. So the court believes that bond is. I'm not going to raise it, but if the bond is set appropriately and deny the request for a bond reduction, bond will continue.
Thank you, Your Honor.
Court does call the case People versus Denicia Charles.
Rob Dowers is supposed to be turning it up.
Good morning, Your Honor. Christina Sachs is standing in for Edward Drukes with Ms. Charles consent. Is that correct? Ms. Charles, please state your name for the court.
Denicia Charles.
All right, thank you.
Your Honor, we're asking for an adjournment.
Without objection, probable cause conference will be adjourned to December 11th, 2025, 9 a.m. Bond continue.
Thank you, Your Honor.
Court does call the case People versus Charles Hudson.
And good morning, Your Honor. Christopher Coyle, the attorney on behalf of Mr. Charles Hudson. I say that because I understand there's a Christopher Coyle on the docket today as well.
Oh, I thought that was you.
No, never mind. Mr. Hudson, can you state your name for the record? Charles Hudson. Judge, we're here for the PCC, and the prosecutor and I are attempting to get perhaps some type of resolution here at the district court level before we move up to the circuit court. So we're just asking for a little bit more time and adjourn the PCC out.
The 11th, will that work for you?
Yes, Your Honor.
Probable cause conference, December 11th, 2025, 9 a.m. Bond continue.
Thank you.
Thank you. Court does call the case People versus Shane Edgesier.
Morning, Your Honor. Saxon for Shania Desir is present to my right. So please state your name for the court. Shania Desir.
Now, on to the matter of Terrence Ginyard. This is where the stakes really ramp up. Ginyard's plea agreement could reduce his felony charge significantly. He's making a gamble on his future, and the court will have to decide. Does his payment history warrant this leniency, or is it just too risky?
Well, I'll ask it later. I'll just go December 11th, 2025, 9 a.m. on this. Bond continue.
Thank you, Your Honor.
Thank you, Your Honor.
Court calls the case People versus Marissa Dix.
Good morning, Your Honor. Robert Elman with and on behalf of Ms. Dix.
Your name?
Good morning, Your Honor. Marissa Dix.
Thank you.
Your Honor, may we approach in this matter?
Sure, I'm not busy. Come on.
Thank you, Your Honor.
Our record should reflect you had a bench conference in this case. You're requesting an adjournment. You're requesting an adjournment.
Yes, Your Honor, for purposes of PCC, yes, we're trying to work out a resolution here at this level, and we need a little more time to do that.
I'll adjourn it to December 11th, 2025, 9 a.m. Also, as to bond, defendant is on a bond violation. Given the nature of the charges, her bond was revoked because she was in the exclusion zone. Counsel has explained what happened, all right? And also that something the court didn't know is that she was in contact with community corrections while this whole thing was happening, which the court did not know, but that all aside. So I'm going to reinstate her previous bond with its conditions, all right, so she can be released. The other thing is that I've apprised counsel to work with the prosecutor to, she was going to take her bike to work, and it's going to be cold out there. So I think she should be able to take an Uber, see if we can draft or reset the exclusion zone so that a major thoroughfare she can take a major thoroughfare so she can get to work. And so that way she can tell the driver, yes, I can go down this road without fear that she's clipping the edge of the zone. All right.
Thank you, Your Honor.
So her bond is reinstated. I'll need an order with all the conditions. All right. She can be released.
Thank you, Your Honor.
All right, thank you.
Thank you, Your Honor. Thank
You're
you so
welcome.
much.
Court does call the case People versus Desiree Gray.
And good morning again, Your Honor. Robert Elman with and on behalf of Ms. Gray, who should be here over Zoom. Ms. Gray, can you please state your name for the record?
There she is. Well, we see her finger. Oh, there she is.
Desiree Gray.
Thank you, ma'am. Go ahead. She's waving.
Yes, Your Honor, we're waiving. There should be a signed waiver in the file.
Ms. Gray, you're waiving your right to a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them?
Yes, Your Honor.
You understand you'll not have that hearing, you'll proceed to circuit court for further resolution?
Yes, Your Honor.
People also waive their right?
Yes, Your Honor, there was an offer extended for this waiver before.
Yes, go ahead, please.
My understanding, the offer is that the defendant is going to waive up and plead to 2 counts of possession of cocaine less than 25 grams under 7411 in circuit court.
That's correct, Your Honor.
All right. Preliminary examination having been waived, defendant found over to circuit court on all 4 counts.
Thank you.
Mr. Alvin.
We waive a formal reading. Sorry, Your Honor. Stand mute to the charge.
Defendant having waived formal reading, standing mute, court will enter not guilty plea as to all charges. Pretrial will be set for
January 7th at 1:30 with Judge Conlon.
January 7th, 2026, 1:30, Judge Conlon. Bond will continue.
Thank you, Your Honor.
All right, thank you. Thank you, Ms. Gray.
We've just heard some major legal motions today. As we move towards the final decisions in these cases, tensions are building. How will the judge rule on bond reductions and adjournment? The choices made in the coming moments could define the future of these defendants. Justice hangs in the balance.
Assistant Public Defender Hannah Apple appearing on behalf of Mr. Griffin and the remaining 3 files.
All right.
Your name for the record, sir.
Joseph Person Griffin.
All right. Requesting an adjournment on these.
Yes, we are missing discovery on the 3 files that the PD office represents Mr. Griffin on.
And I'm still waiting for some video discovery that the prosecutor's office is preparing, so we ask for adjournment for that.
All right. And maybe this is the case to ask it on. Do we have any idea? I realize it's not anybody's fault that it's part of the new, well, it's not part of the new system, but there's a glitch or something. Do we have any idea when that's going to be resolved for discovery purposes?
I can give a more definite answer for the court in a few minutes, but my understanding is that there are fixes underway for the public defender's office to be able to receive the discovery, and we're working through that. And I think for private counsel, it's going very well. So we are just in the process of getting it. I think a timeline is probably next week we'll have it all sorted, but I'd be happy to get a more definite answer for the court in a few minutes.
Okay, if we could, but
yeah, for sure.
When you say it's working for private counsel, that is that going to, if counsel's conflict counsel, are they grouped in with private counsel or?
Irritatingly, it depends. So
okay, that's definitive. No,
that's it has to do with the integration between the new system and the old system. That's where the sort of difficulty is. I'll give the court a better answer.
I spent some time on the phone with 2 people from each of the offices, both of whom had no idea what they were talking about, and I understood more. So they confused me more than anything in the world. All I knew is there was a problem at the end. All right.
I will work on that.
Okay. I should have just gotten to you because I knew. Okay.
For the Griffin issue specifically, some of it has gone through via email already, but there may just be more coming. I'll try to get the court a better answer.
All right. What I will do is I will grant the adjournment. We don't just bring him back. Normally I'd go 2 weeks, but let's just do the 3 week. So I'm going to adjourn this probable cause to December 11th, 2025 at 9. And then hopefully things will be resolved. All right. Thank you, Mr.
Thank you, Your Honor. Your Honor, one more request. Would the court consider release to inpatient treatment? All these cases, I believe, are related to substance dependence issues.
I don't have an issue with that. The public defender normally would prepare an order or a standard order. So if it's submitted on these,
I will send that to the court later today.
The only thing that has to be included in that is that if he's in custody and he's released that way, that there would need to be a tether run.
Okay.
Fair enough. Thank you, Your Honor.
Right.
Thank you.
What an intense day in the courtroom. From plea agreements to bond decisions, the stakes couldn't have been higher. If this case shocked you, hit like, drop a comment, and subscribe for more real courtroom stories. We'll bring you more drama, legal insights, and jaw-dropping twists next time.